Hello, wonderful people. Thank you very much for watching this video. This is your one and only TA. This is Tutorial with Francis. I'm very happy that you've made the time to watch this. My name is Francis Ohimen Anani, and if this is your first time that you are watching videos from my end, just like this video, visit the YouTube page, like all of them, share all of them, subscribe to all of them. If you have comments, you can let us have them. If you also want to, get in touch, this is my email account. Just let's be social. Yeah. So today we are dealing with, okay, I've already introduced myself. We are dealing with a very important topic. I've had this session in church a few times, and I believe it's time that I have a video on it, for the folks out there to benefit from. Then again, as I keep on saying, this is a session that we will try as much as possible to keep it straight, to keep it simple. We won't try to be too legalistic. There's no need intimidating you guys with all legal words and all that. It's not the purpose of this session. So we'll just try to keep it very simple. All that we want to know about is to have some introductory ideas on what is a will. I'm sure you've all heard so many stuff about wills, and why do I need a will? What is a will? And blah 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 and all that. So today we'll just try and keep it short and simple as I do it. I'll try and break it down so that you understand what I'm actually trying to say. So be with me, and then let's go through this session together. Yes. Good. So in this session, what we'll be doing basically is going through what is a will, who can make a will, what properties can a will cover, why should I draft a will, or why should I get a lawyer to help me with a will when I am young? So I am young, why do I even need a will? Must my will necessarily be in writing, or I can just say to my family members, how many witnesses do I need, and what happens if I'm blind? What happens if I am an illiterate? And who can be an executor? So these are very, very important bits that you need if you intend to make a will, or maybe not now, but in the future. It's better that you educate yourself so that you don't become ignorant about some of these matters. It also helps. As a lawyer, it's a bit easier when you are dealing with persons who have a bit of knowledge about what a will is. Makes the whole process very smooth because they're able to make available the information you need, to get the work done easily. So this is the reason or the rationale behind this session. Good. So let's start. What is a will? If I was in a class, I'll be asking, yes, what is a will, or what is your idea about a will? If you have an idea different from what I'll be sharing here, why not? You can put it in the comment section, and then we can discuss it. Yeah. So what is a will? If you're watching, just think about it. I'm sure there are so many ideas that you may have in your mind, but we'll just keep it straight and simple. Yeah, as I try to do all the time. Good. So a will essentially is a declaration. A declaration is more like it's a statement. It's something that you say in a prescribed manner, which means that there is a manner that your statement must follow. So even though they are, at the end of the day, they are your words, it must follow a particular order. The law provides, certain requirements that every will must meet. So it's your words following a particular order, showing your intentions. So it's essentially your intentions. So is it with regards to matters concerning you, which you would want to put down and can only take effect upon or after your death. This is very important. Meaning that if I'm alive and I have a will, my will is as worthless as anything. It only takes effect after my death. This also means that if I make a will today, I can change it as many times as I want because it is of no relevance until I die or after my death. Immediately after my death, then the will becomes important because it will then be a declaration that showing my intentions to my wife and to my children and what I want them to do with my properties or whatever it is after my death. But whilst I'm alive, the will is just like any document. So once you have an understanding of a will, if your will gets missing, why not? You can see your lawyers and they can get you a new one. If it's defaced or you think you've acquired more properties you want to add, of course there are ways of going about it. Because you can even for properties that you are yet to acquire, you can make provision for them in your will. But let's say you've acquired so much property that you want to change your will, why not go ahead and change it? Because once you are alive, they are just intentions. They are just intentions. So they can be changed as many times as possible. So if you understand a will to be this, then you are not too scared that once I do a will, it means I've died. No, your will will only take effect after your death. So the fact that you are making a will does not mean you are going to die. It only means that you are preparing for your family. You don't want any chaos to happen after your death. Because the sort of chaos that especially the children and the surviving spouse go through after marriage sometimes is very troubling. So it is in your interest that you get this documents down before you join the ancestors. So please, let's all try and take this will business serious because most of the time when you hear comments like it means I'll die, it's not even expensive, honestly. I mean, if you compare it to the problem it is curing in the future, I don't think it's expensive. It's not expensive. You can speak to your lawyer and then agree on something, but it's very expedient that we all try as much as possible to organize our affairs before leaving this earth so that at our demise, our wives and children don't suffer at the hands of rogue and unscrupulous, family members who would want to come and benefit from where they did not sow. Good. So then again, a will is not only limited to your properties. It could be appointing executors. It could be appointing guardians. So you can say that at my death, I want my sister or I want this one to take care of my children. Even in certain situations, you could even use a will to determine where it should be buried. Except that this point is a bit contentious because under the Ghanaian law, the body belongs to the family. And a will is supposed to be your something personal to you. So once you are no more, your body does not belong to you. So if your body does not belong to you, then you cannot be dictating what should happen to your body. But why not? I mean, we hear this idea out there, and you hear people wanting to include it in their will. Of course, if you have a family member that would want to respect you and respect your wishes, why not? But let's also understand that if the family decides to do otherwise, it may not be too wrong. But then again, the law is always evolving, and there's an interpretation to almost every position of the laws. Why not? Good. So it is just an intention. It is only a declaration. It only takes effect after your death. After your death. So if you have the will today and it's missing or someone steals it, no problem. You just have to go for another. You just have to go to your lawyers and then they will help you with another. Well, just that your lawyers would have to put in a clause revoking all previous wills. And of course, this is a general clause in all wills, so you don't even have to worry about that. Yes. So as I said, okay, I'm sure it is captured elsewhere. Yeah, I'm sure it is. So the point I wanted to talk about is that the prescribed manner that the law refers to essentially is on the fact that the will must be written. It must be written down. So I cannot be lying on my bed at the point of death, and I'll call my wife and children and tell them that I am about dying. So if I die, this property here, this my wonderful suit, this my shirt, this my earpiece, I give to this my phone, I give to, of course, that is, in some, so under our laws, it may work, but it has its own problems. Has its own problem, because as to whether the witnesses of that statement are even saying the truth, that's another problem. And as to whether they even follow the procedure for that, is also another problem. So yes, of course, you may be on your deathbed and you may still make wishes that can be respected, that can be upheld in court, but it's difficult compared to where these statements are actually written down and are filed at the court, and at your demise, we only have to go and bring it to open it up. So once all the conditions necessary for a valid will are in place in respect of your will, you really don't have a problem. You really don't have a problem unless maybe there are issues with the signature, the persons that witnessed it, we'll be going or we'll be looking at some of those points pretty soon. Yes, I hope it is clear. Good. So this one is really fundamental. We are saying that a will is only a declaration, meaning that it only comes to effect after your death. It is only a declaration. So once you are living, a will has no effect. It really has no effect. So nobody would really care what is in your will once you are alive. It's honestly worthless. But once you die, that is when we see the potency of the will. So once you are alive, it is only a declaration. It's only a statement of your intention that you have made, but can only take effect upon your death. And I've already mentioned that wills are revocable, which essentially means that if you are alive, you can always revoke it, you can always change it, you can always cancel it, and then make another one. Nobody stops you. It's only your intention, it's only your declaration. It's not binding on you once you are alive. It only becomes binding after your death. So if I have a will and I'm giving something to someone whilst I'm alive, the person cannot come and claim it. No, at that point, whatever it is still belongs to me. It is only after my death that the person has an interest in that. And then through the court processes, the person can become the actual owner of whatever property that I devised or I bequeath to that particular person. So it can be revoked, guys. Let's note this. And also it can also cover property that you acquire even after making the will. So we have something we call residual clause. So now we won't see residue clause in there, which shows that in the event that I acquire properties after the making of the will, I am giving it to, say, my daughter, or I'm giving it to, say, my wife, or I'm giving it to my mother. So even though you may not have acquired the properties, now, if you make the will because of the residue clause, it can cover all those properties, unless, of course, after acquiring those properties, you want to give them to certain persons whose name were not captured under the residue clause, because the residue clause should say that any properties I acquire after my death, I give them to Francis. But let's say you acquire these properties and you want to give them to a particular person whose name is not captured in the will, then you may have to do what we call a codicil. So a codicil is more like a supplement to a will. It's a document that more. Yes, I mean the better word is a supplement to a will. So if you are done with your will and then there are new additions or there are new stuff that you want to subtract, you can do a codicil. You file it in the court, it will be attached to the original will. But from experience and from advice from senior lawyers, what they normally say is that it is not good to have a will and then a codicil, because you may not, you just can't be certain what will happen in the will's registry, and then you go and your codicil may have, detached itself from the actual will, it's nowhere to be found, a whole lot of issues. So, some senior lawyers would advise that instead of making a codicil or a supplementary will, why don't you make a new will? Then it depends on the circumstances. There are times where it is not really worth it to make a new will. You can just make a codicil and then are good to go. It all depends on the circumstances at hand. I'm sure the lawyer who is advising will definitely know what to do, whether to make a new will entirely or just to make a codicil to, cover for the new properties acquired and who those properties should go to. But if the properties are to go to, say, your wife and children whose name are already captured in the residue clause, then there's really no need for the codicil. Because even though the property did not exist as at that time, it will still go to them. It's as simple as that. Yes. So who can make a will? So our laws there, the Wills Act says that anybody above 18 who is not suffering from insanity or infirmity of the mind. So if you are very sane and there's no problem with your mind and that you can understand the nature or the effect of the will, you can make a will. So if you understand that a will takes effect after my death, if you understand that it is only a declaration, why not? You can make a will. So that is the position of the law. Once you are 18 years and above, and you are sane, and you understand the nature or effect of a will, as to you understand that a will, as I've already mentioned, takes effect, after my death. It is only a declaration. I can change it as many times. Once you understand these basic concepts about a will, you can make a will. And a will would only cover personal property. This is important. It must only cover personal property. A will cannot cover properties belonging to your father, belonging to your mother, belonging to your wife, or belonging to whoever. No, it must be properties that you have acquired yourself. So if it's a property from your mother, be sure that it has been devised or has been alienated to you. Be sure that you have either the title documents or there's something showing that those properties are your personal property. Other than that, in the event that your will is read, you can be challenged. So if you fix in a property that does not belong to you, that bit of the will can be challenged, not the entire will. Maybe it may just be that bit of the will can be challenged, and that provision may be declared null and void because that property may not be yours. So it must only cover personal property. So properties that you are entitled to at the time of your demise, or properties that you will be entitled to at the time of making the will, or properties that you may have acquired after the making of the will and possibly covered in the residue clause. So the underlying point is that it must be for personal property, please. Personal properties. So yes, as I've already mentioned, it could be for a property that you are entitled to after your death. But once they are personal properties, so maybe you know that you are going to get some properties from your dad or your mother, why not? You can put them in your will because you are assured of these properties. So once these persons are no more, they become your personal property. But if at the time of making the will, they were not yours, but if you anticipate that they will become yours, why not? You can put it in. But the tricky bit is that if at the time of your demise, those properties had not become yours, then clearly whoever the beneficiaries are cannot get it. So that is the tricky bit of it. Good. Okay, so at this point, why should I get a will when I am young? So when I say young here, I don't mean when you are 18, 19. I mean when, you are not old. I know that's funny. So all that the point that we are trying to say is that you don't need to wait till you are 85, till you are 90, when you are so frail and so weak, and your mental capabilities are a bit in question before you come and make a will. So when you are young here, what we are just trying to say is that when you are not that old, when you are your mid-ages when you are 50, 60, because clearly at that time, you may have acquired most of the properties that you would have acquired in life. So at that point, it's a good time to make a will. So I put it, however, there's no need for an will. So if you are 18 years and you honestly have nothing, why would you want to spend money to make a will when there's really, or there will be nothing in the will? It really doesn't make sense. Not necessarily nothing, but not much of the value, because you honestly don't have much. So what the point we want to put across here is that it is better to make a will when you are still at your peak, your mental faculties are functioning 101%, and everything is working for you. That is the point that you make a will. Don't wait till you are in your 80s, 85, and it becomes a problem. And here we are saying that depending on your age and the capacity of your mind, your will could be challenged on grounds of insanity. So if you are 90 years and you are making a will, and almost everybody in the family know that you are having issues with your, with your mind, you are always making funny jokes, making funny requests, calling for dead persons, those stuff, which is very normal with, older people, and you want to make a will at that time. Someone could challenge, because someone could say, well, maybe instead of calling, or instead of bequeathing this property to Kweku, you mentioned Kwesi, because normally you seem to always be calling Kweku when in fact the person you are calling is Kwesi. So there could be challenges. Maybe you are always mixing names and all that. And unfortunately, that does not happen in the will, but someone could challenge that in your life, or at least that is how you've been calling the person. So let's say that the person is called Amuako, and all the time you've been calling the person Amankwa, and in your will you put in Amankwa. The person could come and say that you are actually referring to him, because that is how you have been calling all this while, which may not be the fact. But you see, it may be upheld because of the challenges with your mind, or because of the mild insanity that you may be going through. It is not all the case, but we know that there are certain older persons that may actually have issues with their mind. They know how they think and all that. So if a beneficiary or a non-beneficiary has a strong case to suggest that he should have been a beneficiary, but because of problems with your mental capacity, you swapped, or you changed, or they can actually put your will in question because of your mental capacity. Also, depending on your age, there could be grounds of fraud. So you could have very rogue sons and daughters who can force, not necessarily force you, but lie to you for you to make certain words that at the end of the day may be deemed as fraudulent, or may be deemed as not coming from you. Because, so let's say you have 10 children, and possibly you have even not necessarily shared, but almost all your 10 children are all living in one of your apartments. And then in your will, there's this sneaky son who manages to get you to make a will, and all the properties have been devised to this child. The will can be challenged on the basis of fraud. That this will is not coming from father, or it's not coming from mother, because that was not his intention. So on this space, it's not really about your mental capacity, but sometimes even the relationship you have, or the authority. So this point, delves into the undue influence, and then the duress bit, where the children have so much power, especially the ones who may be taking care of you. They have so much power that they determine what must be in the will or not. And sometimes not necessarily they forcing you, but then such an older person can make a will, and then they will go behind and change things and come and ask you to sign. And because of the frailty and all that, you can't even detect that the will is a fraudulent one. So you don't want all these problems coming in. Sometimes you have children leaving you, saying that I'm the one providing for you, I'm the one giving you this. So if you don't give me this share of your property, you will see in this house. You don't want all these issues. These are actually matters that happen. So you really don't want these issues. So in your 50s, 60s, 70s, just get a will. Even in your 40s, if you are quite enough, if you understand what I'm saying, your will can even cover properties that you are yet to acquire in the future. So you can be in your 40s, still make a will and just put in a residue clause saying that all properties I acquire after the making of the will, I give to my wife and children. Full stop. So whatever you acquire will be going to your wife and children, and you will not need to make a new will. You get it? So let's just not wait to, we hit that point where someone would come and challenge us when in fact it may actually be our doing. Which means that, that is actually what we wanted to say, but we just have children who are just being too smart. So that is it. Must a will be in writing? I've already mentioned it, that yes, a will must be in writing, signed by the testator, and the testator is the person making the will. So it must be signed by you. And it is important to know that you must only sign at the last page of the will, not in the middle, not on the first page, at the last stage, because the position of the law is that all devices that are after your signature are not effective. So let's say, I don't know whoever drafts it, but if a lawyer drafts a will and then your signature portion, the witness portion is in the middle, and after that there are properties given to certain beneficiaries after the position is that such device after the signature are not effective. So it always helps that you sign at the last page. And in situations where you cannot sign, you can always delegate someone to sign for you, but in your presence. So if you cannot sign, there should be someone there directing the person to sign in front of witnesses, in front of the two witnesses. Yeah. So as I've already said, with the witnesses, you need to, how many witnesses do I need? You need 2 witnesses. You need 2 witnesses. Present, so they must be present and at the same time seeing you sign. But the position is that when they are signing, the 2 need not be together. But when you are signing, the 2 must be together. So if I'm signing my will, I need my 2 witnesses here to see me sign. But if they are signing to concur that they saw me sign, the 2 witnesses need not be at the same place. I hope this is clear, but to avoid all this technicality, make sure that all the witnesses and you are in the same room and you all sign at the same time, so that you don't give room for interpretations and on all that. Yes, and I've already mentioned that if someone signs for you, you still need a witness. You still need the witnesses. And what if I'm a blind person? Yes. You can appoint someone, a competent person, to read. When I say competent person, I mean someone who can actually read and understand the content of it, and it's sane and mental faculty, it's fine. So a competent person, not below 18, above 18, to read for you and explain to you in the language that you prefer. Once you understand, you can just either sign or what tampering is just okay. So we'll just bring an ink and then you just stick your thumb in there and then you tamper beautifully. So the fact that you are blind or illiterate really doesn't matter. You can still get a will done in your name. So normally this process is called jurat, jurat. So when we hear jurat, that is what we are saying, where someone reads the content of a document to you, and then you sign, and the person signs saying that I read this document to the person, and he seemed to understand before signing. Yeah. So another very important bit which I need to stress on before I bring this session to a close is the executor. So the executor is the person who is appointed to ensure that everything in the will is obeyed. Because understand, it is a document that has been filed in the court. So at your demise, what next? There has to be a person who would follow up in the court, get the lawyers to apply for probate, for the document to be brought out, and then to be read to the family members. That person is what we call an executor. So if you intend making a will, 3 persons that you need, the executor and then your 2 witnesses. And then with the help of your lawyer, you can get it done. So that is the executive. Could be a man, could be a woman, but here the position is that the person has to be above 21 years. Remember that at the witness bit, the person has to be above 18, but for the executor, the person has to be above 21, and still the point is still clear. The person must be seen, and then the mental faculties must also be working. And anybody can be an executor, except that if you are to benefit, even with this, I mean, even with this, most of them are not. It is not advisable, but it is not wrong. So let me just be clear. It is not advisable, but it is not wrong. So you can be a beneficiary and then can also be an executor. But if you are a beneficiary, you cannot be a witness. Let me make this point clear. If you are a beneficiary, which is that if you are going to get something from the will, you cannot be a witness. And this is clear. It actually makes sense. Just imagine your father making a will. Your father has 10 properties at East Legon, and you are just 2. And your father is giving 9 of them to your other sibling and only 1 to you. And you are the witness supposed to sign. I mean, clearly, that will not be a very good experience. And nobody knows what you can do afterwards. Because now you know the contents of the will. So if you are a witness, you cannot be a beneficiary. Or if you are a beneficiary and then you force yourself to witness, you are not entitled to whatever is in the will. But however, if you are an executor, you can also be a beneficiary. But it's not something that we advise, but it is not wrong. It is not wrong. It is not wrong. Yes, so I guess that is that. I guess let me see. Yes, so I think I've covered everything that I need to. So I don't know if you have any question, you can always put it in the comment box, and then we try to respond to it. Thank you.